This is my YouTube channel, and in this video I'm going to talk about the harassment of the women at the workplace. And I'm continuing my second video. Then I'm talking about the major penalties. Those will be given to the person who is accused of having a harassment with some lady. So he is basically a reduction to a lower post. Major penalties: reduction to a lower post or the time scale, or to a lower stage in the time scale. Second, B, compulsory retirement. C, removal from the service. D, dismissal from the service. D, A, suspension or the cancellation of the professional license. E, a fine. A part of the fine can be used as a compensation for the complainant. In case of the honor, the fine shall be payable to the complainant. 5. The competent authority shall impose the penalty recommended by the inquiry committee under the subsection within 1 week of the receipt of the recommendations of the inquiry committee. 6. The inquiry committee shall meet on a regular basis and monitor the same situation regularly until they are satisfied that their recommendations subject to decision, if any, of competent authority and appellate authority have been implemented. 7. In case the complainant is in trauma, the organization will arrange for psychosocial counseling or medical treatment or for additional medical leave. 8. The organization may also offer compensation to the complainant in case of loss of salary or other damages. 5. Powers of the inquiry committee. The inquiry committee shall have powers to summon and enforce attendance of any person and examine him on oath. B, to inquire the discovery and production of any documentary or audio or video evidence. C, to receive evidence on affidavits. D, to record evidence. Second, the inquiry committee shall have the power to inquire the matters of harassment under this act, to get the complainant or the accused medically examined by the authorized doctor if the necessary, and may recommend appropriate penalty against the accused within the meaning of the subsection of section 4. 3. The inquiry committee may recommend to ombuds for appropriate action against the complainant if the allegations leveled against the accused found to be false and made with mala-fide intentions. 4. The inquiry committee can instruct to treat the proceedings confidential. 6. Appeal against minor and major penalties. Any party aggrieved by the decision of the competent authority with whom minor or major penalty is imposed may, within 30 days of the written communication of the decision, prefer an appeal to ombuds established under section 7. Second, a complainant aggrieved by the decision of the competent authority may also prefer appeal within 30 days of the decision to the ombudsperson. 3. The appellate authority may, on consideration of the appeal, any other relevant material, confirm, set aside, vary, or modify the decision within 30 days in respect of which such appeal is made. It shall communicate the decision to both the parties and the employer. 4. Until such a time that the ombudsperson is appointed, the district court shall have the jurisdiction to hear appeals against the decisions of the competent authority and the provisions of the subsections 1 to 3 shall mutandis apply. 5. On the appointment of the ombudsperson, all the appeals pending before the district court shall stand transferred to the ombudsperson, who may proceed with the case from the stage at which it was pending immediately before such transfer. 7. Ombuds. The respective governments shall appoint an ombuds at the federal and the provincial levels. Second, a person shall be qualified to be appointed as an ombuds person who has been a judge of High Court or qualified to be appointed as judge of High Court. The ombuds may recruit such staff as required to achieve the purposes of this act, and finances will be provided by the respective governments. Ombuds to inquire into the complaint. Any complainant shall have the option to prefer a complaint either to the ombuds or to the inquiry committee. The abuse shall within 3 days of receiving a complaint issue a written show case notice to the accused. The accused, after the receipt of the written notice, shall submit a written defense to the abused person within 5 days, and his failure to do so without responsible cause to the abused may proceed ex parte. Both the parties can respect themselves before the abused person. The abused shall conduct an inquiry into the matter according to the rules made under this act and conducting procedures as the abused deems proper. For the purposes of an investigation under this act, the abused person may require any office or the members of the organization concerned to furnish any information or produce any document which in the opinion of the abused person is relevant and is helpful in the conduct of the investigation. The abused person shall record his decision and inform both parties and the management of the concerned organization for the implementation of the order. 6. The abused shall decide a case or appeal as the case may be within a period of the 90 days. 9. Representation to the president or the governor. Any person aggrieved by the decision of the abused person under the subsection 5 of the section 8 may within 30 days of the decision make a representation to the president or the governor as the case may be, who may pass such order thereon as he may deem fit. The president of the governor as the case may be shall decide such representation within 90 days. Within 90 days. 10th, powers of the abused person. The abused person shall, for the purposes of this act, have the same powers as the vested in the civil court under the Code of the Civil Procedure, 1908, Act 5 of 1908, in respect of the following matters, namely, summoning and enforcing the attendance of any person, examining him month, compelling the production of the evidence, receiving evidence on affidavits, force issuing a mission for the examination of the witnesses. 5. Entering any premises for the purpose of making any inspection or the investigation. Enter any premises where the abused person has a reason to believe that any information relevant to the case may be found. 6. The abused person shall have the same powers as the High Court has to punish any person for its attempt. Abused person shall, while making the decision on the complaint, may impose any of the minor or the major penalties specified in the subsection of section 4. 11. Responsibility of the employer. It shall be the responsibility of the employer to ensure implementation of the act, implementation of the section, including but not limited to incorporate the code of conduct for protection against the harassment at the workplace as the part of their management policy, and to inform inquiry committee referred into section 3 and designate a competent authority referred to in section 4. Second, the management shall display copies of the code in English as well as language understood by the majority of the employees as conspicuous place in the organization and the workplace within 6 months of the commencement of this act. 3. On failure of the employer to comply with the provisions of this section, an employee of the organization may file a petition before the district court, and on having been found guilty, the employer shall be liable to fine which may extend to 100,000 rupees, but shall not be less than 25,000 rupees. 25,000 rupees. Provisions of this act in addition to or not in derogation of any other law. The provisions of this act shall be in addition to or not in derogation of any other law for the time being in force. 13. Power to make rules. The federal government may make rules to carry out the purposes of this act. Code of conduct for the protection against harassment of the women at the workplace. Whereas it is expedient to make the code of conduct at the workplace, etc., to provide protection and safety to women against the harassment, it is hereby provided as under The code provides a guideline for behavior of all employees, including management and the owners of the organization, to ensure a work environment free of harassment and intimidation. Harassment means any unwelcome sexual advance, request for sexual favors, stalking or cyber stalking, or any other verbal, visual, written communication or physical conduct of sexual nature or sexually demeaning attitudes, including any gestures or expressions conveying derogatory connotation, causing interference with work performance, or creating an intimidating, hostile, or offensive work environment, or the attempt to punish the complainant for refusal to comply to such request, or is made a condition for the employment, or discrimination on the basis of the gender, which may or may not be sexual in nature, but which may embody discriminatory and prejudicial mindset or notation, resulting in discriminatory behavior on the basis of gender against the complainant. Provided that a single incident having the effect of making a person uncomfortable or creating a sense of fear or panic at the workplace is also harassment. A single incident having the effect of making a person uncomfortable, creating a sense of fear or the panic at the workplace is also harassment. Explanation: there are three significant manifestations of harassment in the workplace environment. Abuse of authority: a demand by the person in authority, such as supervisor, for sexual favors in order for the complainant to keep or obtain certain job benefits, be it a wage increase, a promotion, training opportunity, or transfer, or the job itself. Creating a hostile environment: any unwelcome sexual advance, request for sexual favors, or any other verbal or physical conduct of sexual nature which interferes with individual's work performance, creating, intimidating, hostile, abusive, or offensive work environment, or discrimination on the basis of gender, which may or may not be in sexual nature, but which may embody a discriminatory and prejudicial mindset or notation, resulting in discriminatory behavior on the basis of gender. The typical hostile environment claim in general requires finding of a pattern of offensive conduct. However, in cases where the harassment is particularly severe, such in cases involving physical contact or the gender-based discrimination, a single offensive incident will constitute a violation. See, retaliation: the refusal to gain a sexual favor can result in retaliation, which may include limiting the employees' options for future promotions or trainings, distorting the abolition reports, generating gossip against the employer, or any other ways of limiting access to his or rights. Such behavior is also part of the harassment. 3. Informal approach to resolve a complaint of the harassment may be through mediation between the parties involved, or by providing advice and counseling on strictly confidential basis. 4. A complainant or a staff member designated by the complainant for the purpose may report an incident of harassment informally to a supervisor or the member of the inquiry committee, in which case the supervisor or the committee member may address the issue at her discretion in the spirit of this code. The request may be made orally or in writing. 5. If the case is taken up for investigation at an informal level, or senior manager from the office or the head office will conduct the investigation in a confidential manner. The alleged accused will be approached with the intention of resolving the matter in a confidential manner. 6. If the incident or the case reported does constitute harassment of the higher degree, and the officer or a member reviewing the case feels that it needs to be pursued formally for disciplinary actions with the consent of the complainant, the case can be taken as the formal complaint. 7. A complainant does not necessarily have to take a complaint of the harassment through the informal channel. She can launch a formal complaint at any time. 8. The complainant may make a formal complaint through her in charge, supervisor, CBA nominee, or the workers' representative, as the case may or directly to the member of the inquiry committee. The committee member approached is obliged to initiate the process of the investigation. The supervisor shall facilitate the process and obligated not to cover up or obstruct the inquiry. Ninth, assistance in the inquiry procedure can be sought from any member of the organization who should be contacted to assist in such a case. Thus, the employer shall do its best to temporarily make adjustments so that the accused and the complainant do not have to interact for official purposes during the investigation period. This would include temporarily changing the office in case both sit in one office and taking away any extra charge over and above their contract, which may give one party excessive powers over the other's jobs conditions. The employers may also decide to send the accused on leave or suspend the accused in accordance with the applicable procedures for dealing with the cases of the misconduct if required. 11. Retaliation from the either party should be strictly monitored during the process of the investigation. Work evaluation, daily duty reporting structure, or any parallel inquiry initiated should be strictly monitored to avoid any retaliation from either side. Filing counter lawsuits for defamation, etc. are also retaliation. The abused person of the inquiry committee, as the case may be, should take notice of this in his or its proceedings. 12. The harassment usually occurs between the colleagues where they are when they are alone. Therefore, usually it is difficult to produce evidence. It is strongly recommended that the staff should report an offensive behavior immediately to someone they trust, even if they do not wish to make a formal complaint at the time, although not reporting immediately shall affect the merits of the case. And 13. The code lays down the minimum standards of the behavior regarding protection of the woman from the harassment at the workplace, etc., but will not affect any better arrangement that an organization may have developed, nor will it bar the gains of protection that employees working in an institute may secure from their employees through negotiation. That is all about the harassment of the woman at the workplace. It's the whole topic about harassment of the woman at the workplace. It's the Pakistani law.